Thank you for that introduction, and thank you for sticking around this long. You've almost made it, so congratulations. My name is Arlene Hahn, and I'm a partner at White & Case in the Sourcing and Technology Transactions Group. The lawyers in my group spend 100% of our time on IP and tech transactions, so standalone transactions, banking, finance, capital markets, and of course, IP and tech-driven M&A. So I'm extremely honored and excited to be in Israel today. Israel is obviously a hotbed of innovation, but with the recent deals, the $4 billion Playtika deal last year, the $15 billion Mobileye deal this year, both to foreign sellers, I think Israel is also becoming a destination, a premier destination for any foreign buyers who are interested in buying or building the latest disruptive tech across any industry. So because this is what I do, and because hopefully at some point in your career you're going to contemplate the sale or the purchase of IP or tech, whether as assets or as a whole business, I thought I would share some of my experiences with you, kind of the three things that I would think of that can derail or delay or actually destroy the value of an IP or tech-driven M&A transaction. So these are the types of things that keep me up at night as an outside lawyer. The first is ownership, the second is restrictions and impediments, and the third is process. So ownership sounds easy, who owns the IP? But when it comes to IP, it's actually not that easy. For example, in 1998, Rolls-Royce motor cars went up for sale, and there was a heated battle between BMW and Volkswagen as to who would win the luxury car company. At the end of the auction, Volkswagen swooped in and outbid BMW by 90 million pounds and declared victory. Volkswagen thought it had acquired everything it needed to make the Rolls-Royce car. It had acquired actually quite a few things. It acquired the factory, it acquired the beautiful car design, it acquired the distinctive radiator grille. But what Volkswagen didn't acquire was actually the Rolls-Royce brand name and trademark. Those were owned by Rolls-Royce PLC, the aircraft engine manufacturer. And Rolls-Royce PLC wanted BMW to win that auction. So what Rolls-Royce PLC did is license the brand name directly to BMW for 40 million pounds. And even though Volkswagen and BMW were ultimately able to hammer out a deal where Volkswagen could make the car with the logo, I think it goes without saying that had somebody confirmed ownership before Volkswagen's bid, it would have saved itself a lot of money and probably a lot of embarrassment. So this is obviously an extremely catastrophic example and a somewhat simple example of how you could miss ownership in an IP or tech-driven M&A transaction. But I think in the context of a startup especially, or a tech startup, ownership issues can often be overlooked. What happens is a small company gets together, there are innovators, they start innovating, they're building their brand, they're building their company, and they're not really focused on papering their ownership correctly. And when you bring in a cross-border component, that complicates things even more because IP is jurisdictional. There are different regimes that apply to different countries. So for example, in the US, if you're dealing with invention ownership, there are at least 3 critical things that you need to know that are probably a little different than other countries. First, in the US, absent a written agreement to the contrary, an employee who invents an invention doesn't necessarily, the ownership of that invention doesn't necessarily vest in the employer, even if the invention was conceived on the employment time. Second, the US does acknowledge joint ownership and joint inventorship. So if 2 employees co-invent an invention and one of them correctly assigns the invention to the employer, the other inventor is still free to use that patented invention and even to license it out, make money off of it, and it doesn't have to get the consent or provide an accounting to the other inventor or the other owner. And the last thing is US courts actually don't consider an agreement to assign. The inventor will assign once it's created to be the same thing as a present assignment. So under US law, you really have to have a present assignment. And you really need to make sure that even though the patent office may say X company is the owner of the patent, you actually have to go underneath, look at the chain of title, make sure that all of the inventors executed proper assignments all the way through to the target. And of course, there are other nuances for other IP. For copyrightable code, sometimes it's covered by the work for hire doctrine, sometimes you need an assignment. A lot of times, especially in the startup scenario, people think that just because they have possession, physical possession of the code on their servers, that means they own the code. And that's not always the case, certainly not in the US if it's created by contractors or third parties who had no written agreement. When it gets to things like trade secrets and know-how, obviously that gets even more difficult. We're talking now about information that resides in people's minds. And you do have to make sure that that's been properly papered, that's been properly memorialized, and especially for trade secrets, that the efforts that you've taken to keep that information secret are sufficient. So a lot of times companies enter into kind of form NDAs and they're not thinking about the trade secrets that are being protected. So the NDAs will have, say, a 5-year term. That may not work for a trade secret. So you really have to be careful about buttoning up all of the knowledge that you have in your employees' heads. And finally, with trademarks, probably the preliminary question you all know is it a first to file or first to use regime? The US is a first to use regime, but even then, courts are kind of split right now in the US as to whether, as between a manufacturer or a distributor, if there's no written agreement about ownership, which party owns the trademark, and it may not always be the first party to use it. So you do have to be careful of those issues. The second issue I'm going to talk about is restrictions and impositions. So even if you own IP, that's just half the story, because IP can be used for a multiple of reasons. You can use it defensively, offensively, to generate licensing revenue, as collateral for securitizations or financings, and a host of other reasons. And there are a host of restrictions and impositions that can basically render ownership of IP meaningless, even if you can confirm it. A lot of these are obvious. Liens you can find by public searches. If a target has exclusively licensed its IP to a competitor on a royalty-free perpetual basis, that's not a good thing. And in the case of Rolls-Royce, what had happened is Rolls-Royce PLC had actually licensed the trademark to Rolls-Royce Motor Company, but the trademark license had a change of control termination right. So once Volkswagen bought the motor company, PLC terminated the license and of course licensed the trademark to BMW. The more kind of subtle and nuanced restrictions and impositions that you can find are things that you may not know about or you may not be able to necessarily see in the documents, or you may miss them. One of them is march-in rights. If there's been any governmental funding that's helped create your IP, or if the IP has a special application, a special public interest, like in defense or in healthcare, the government can often just step in and get what's tantamount to a non-exclusive license because it doesn't like the way that you're commercializing your IP. And the last thing we're going to talk about in restrictions and impositions is what I call the dreaded covenant not to sue. And the dreaded covenant not to sue is basically what it sounds like. It is an agreement that you will not sue someone on your IP. A few years ago, we were advising a major tech company on the acquisition of a very small software startup, maybe 2 or 3 employees. And a week before signing, they gave us the rest of their agreements. These were their immaterial agreements, not important, one-offs, standard forms, nothing to see here. Unfortunately, one of those agreements was a 2-page license of a very commercially available component that the target had signed with our client, the acquirer, their biggest competitor. And deep down in the miscellaneous provisions, there was a covenant not to sue. It's written there that basically purported to bind not just the target, but all of its future affiliates, and said, you and your affiliates will never sue us for infringement, ever. Now that sounds crazy. It sounds like, why would anyone sign up to that? Obviously, the startup didn't know what they were doing. Who would sign up to something like that? Again, in the startup scenario, when people are building a company, they don't have leverage, they don't have money, they're not really thinking about these things, they don't necessarily even have lawyers. This is something that, would take some savvy to spot, and this happens quite a bit. In fact, Amazon Web Services, which is arguably the world's most dominant cloud computing services provider, if you look online right now at their terms of use for customers, buried kind of deep in section 8.5 is a fairly broad covenant not to sue that purports to bind anyone who uses Amazon Web Services. That's a standard form agreement. Most people don't expect to see something like that. So this is something that you need to be aware of. The last thing I'm going to talk about is process. So even more than substantive issues, as outside counsel who's advised on literally thousands of deals, I think that process is sometimes the #1 thing that slows down a tech-driven M&A. So there are 3 things that I'm going to talk about. First is sell side. On the seller side, I think the #1 thing you can do if you're preparing for a sale is to actually prepare for the sale and run a pre-diligence process. A lot of companies don't want to spend the money, but you can save yourself a lot of time and a lot of trouble by figuring out what the problems are beforehand. Do you have invention assignments in place? Are they signed by everyone? Do you have an open source policy in place? Do you have a data policy in place? Where is your data stored? Is it stored cross-border or is it transferred cross-border? This is the type of information that any buyer is going to want to know. And if you don't know the answer, you're not going to look very diligent. You're not going to look very organized. Just like when you stage a house to be sold, it's very important to stage your business to be sold. And that's where a good compliance regime comes into play. I was once representing a company that had a mandate that it absolutely had to sell a recently acquired software subsidiary. We had no idea what the provenance of their code was, so we had recommended to the client that they run a source code scan. The client didn't want to pay for it, so they decided to go ahead and launch the auction. And long story short, their preferred bidder, who had a higher purchase price, decided to drop out of the race once they required that our client run a source code scan, and they saw all the issues with the code. Luckily, there was one more bidder left, and we were able to very quickly motivate and remediate the problems with our client's tech people. So before the second bidder even saw the open source scan, we could turn around and say all of these issues have been remediated, we have a plan in place, and that bidder actually ended up purchasing the company. So it was a happy ending, but at the same time, our client really lost out on a purchase price premium because they failed to anticipate the issues that were going to come in diligence. The second way that I think process can fail is something that sounds really simple, but that in-house counsel and outside counsel don't always do, and that is educate your counsel on what the IP rationale is for a deal. Again, it sounds really simple, but at the speed at which auctions are done today, at the speed at which deals are done today, sometimes the business people don't tell in-house counsel, sometimes in-house counsel doesn't tell their outside counsel, why are you buying this company from an IP perspective? Is it the patents? If it's not the patents, is it the code? If it's not the code, is it the brand awareness? If it's not the brand awareness, is it the data? If it's not the data, is it the user recognition? There are so many different things that can add value to a company. And if it's just one slice of those things, you're going to empower your outside counsel to efficiently and properly diligence the deal for you. And I think the last piece of advice I have on a process point is from both a sell side and a buy side perspective is to be commercial. The #1 thing I see delay deals completely unnecessarily is when the person in charge of negotiating a purchase agreement doesn't understand the deal parameters and doesn't understand the transaction. So what often happens, again, in a deal scenario, is that the lawyer negotiating the IP reps in the purchase agreement is either an IP lawyer or a transactional lawyer, but is not both. And when that happens, that almost always delays the deal. The reason why is when you're an IP lawyer, you're excellent at spotting risks. I was an IP litigator for a very long time. Excellent at spotting risks, excellent at identifying liabilities, but you don't always know what's market in a particular area. As Ian had talked about earlier with Qatar, and I think Talia talked about earlier as well, different markets have very different standards as far as liability and risk allocation. So you really need to know those things. So when you're negotiating a purchase agreement or when you're having your outside counsel negotiate a purchase agreement, especially with respect to the IP reps, don't let them do it in a vacuum. Make sure they know, is there an indemnity? If there's an indemnity, what are the restrictions? What are the caps? What are the minimums? What are the deductibles? Is there a bring down at closing? If there's a bring down, is it an MAA bring down? Is it a materiality bring down? How is knowledge defined? Who's in the knowledge bucket? Without knowing any of those parameters, there's really no way that you can effectively draft and craft and negotiate the reps. That's my last piece of advice. Thank you so much.